Rather. Session 2, there's a slight adjustment in terms of who the moderator is. Mr. Alex Moka is unavoidably absent. He'll be replaced with Mrs. Sotoya Makri. Mrs. Sotoya Makri is here, a distinguished colleague. All the way from Port Harcourt, again, forgive me, another bias on my part. The Honorable Justice Lemi Angbo, all the way from Port Harcourt, is also present here, the High Court of Justice, Rivers State. I also just had discussions with Mr. Afam Osigwe, Senior Advocate of Nigeria. He's promised to join us virtually because of some travel constraints. Mr. Patrick Osu for Session 2 will also be here shortly. And finally, Mr. Tobenda Erijokwe, our ICLE guru, will be here. I also spoke to him. He'll be here at about 10:45 or thereabouts for Session 2. Just to say generally that the whole aim of today's event is to examine the rules of professional conduct and offer practical solutions and suggestions around ethical behaviors. Things that we all see. How proper is it for legal practitioners to come out outside the door of the court and start talking to the media over issues that are essentially sub judice? How do we handle those kinds of scenarios? How does it conflict with issues around freedom of expression or the general information that people would say they have, the rights they have to express themselves? What concerns do our colleagues in skirts have around ethical behaviors? These are and many more are some of the issues that would be discussed, and hopefully we would also engage you for the better part of today. So once again, on behalf of the chair of the section on legal practice, you're welcome to today's event. Thank you. We will start off right away by empaneling the Session 1 so that we can make good time. It's 10 o'clock by my clock here. And to moderate this session, we will be calling on my chair, very distinguished Boma Alabi, OON, Senior Advocate of Nigeria, as a moderator. Madam Chair. Now the idea is to have a conversation, so we're not going to stand on, yes. We're not going to have one of those very stiff events. And may we also call profound respect and all humility, my Lord, the Honorable Justice Joseph Olubunmi Kayode Oyewole, Justice of the Court of Appeal. My Lord, you're most welcome, sir. Yes, you can sit down here. Yes. To join him would be my fellow alumni and brother Silk, Dr. Suleiman Usman, Senior Advocate of Nigeria. And to complete the physical panel, we would have my brother and Leonard Silk, Mr. Chukwu Kaikwazom, Senior Advocate of Nigeria. You can sit there. Yes, you can. You can. And so this panel, as I said, will examine the RPC among several other issues. Freedom of expression and information vis-a-vis the issues around having discussions outside courts on matters that are still pending, and so much more. I will now yield to the moderator, Ms. Alabi. Thank you.
Good morning, everyone. And thank you to the chair of the litigation committee, Tony Kukrabo, Leonard Senior Advocate, and his team for putting this together. I'm delighted to be here and to have the opportunity to moderate this session with such distinguished speakers. My job is to moderate, so I will not say much more. I'm simply going to, our speakers have been introduced, and I'm going to start by yielding the microphone to my Lord, Justice Oyewole, to make his presentation, following which Dr. Suleiman Usman, Leonard Senior Advocate of Nigeria, will follow, and then Leonard Silk Chukwukai Kazum, after which we'll have an interactive session. Thank you. My Lord.
Thank you, Mrs. Alabi. And may I say good morning, everybody. Permit me to stand up. Permit me to stand or sit on existing protocol. Now, I want to thank the section on legal practice for inviting me to participate in this discussion, which I consider to be very, very crucial to the future of the legal profession. Using rough statistics, maybe from the lawyers in my own household, barely 25% of new entrants into the profession want to practice, as in remain or take part in litigation. And when you interact with the older generation who are even active in litigation, most of them want to get out like yesterday. And when you also dig deeper to find out what is driving you away from litigation, they go into things, cases get too long to be concluded, litigation drags, you keep objections and needless applications are filed. But when you also now look at even what they do in their day-to-day practice activities, you find out you cannot escape what our Christian brothers, the words of the scripture, that all have sinned and fallen short of the glory of God. But again, we all desire that things should be better. Or like that reggae musician said, everybody wants to go to heaven, but nobody wants to die. Everybody desires change, but nobody wants to change. Enforcement, for me, is the first area we need to look at. When you look at the rules of professional conduct, so many things are covered. But we cannot continue to have the enforcement mechanism that we have now. Even for those who don't watch Premiership football, during the last African Cup of Nations, everybody became a football enthusiast. Footballers don't referee games. You have professional referees taking charge of enforcement of rules of the game. Let us move from self-regulation to having professionals enforce ethical rules in our profession. Globalization has removed so many barriers. We cannot be different in legal profession in Nigeria. We need to move from self-somebody says, take a game and flog yourself. You never, nobody does that. We continue to have whatever we're doing now, which is not working, until we have independent professional regulators taking charge of regulating ethical behavior in the profession. Now, when we look at certain things that we do, yes, all the cases that come up, see, those as client funds, this was all this, but there are areas that we still need to look at. Little things like dressing, punctuality. Regularly, whether we like it or not, we've allowed some of these things in legal cases. You find counsel arguing, oh, it's my fault. It seems counsel is not the intent of litigant. Why should counsel say in the matter that he has been paid? You are a professional. Why should you say in the first place? Why must you complicate your client's life by your own inadequacies? That should be transactions. There are certain arguments we must never allow lawyers to pass in court. We want to take it seriously as a profession. I remember many years back, 20 years ago, when I was still sitting in Lagos, I was having one of the most complicated, whatever we to describe the trial, that they control of some sort of leaders of the previous military administration. And I remember on one occasion, one counsel for one of the accused persons said, oh, I've not served this motion that another friend intends to do. And I said, oh, okay, you have a copy of the motion, extra copy of the motion with you. Okay, give it to counsel. Now service is taken care of. Give you time to react. The very next time that you make a motion, judge has to recluse himself from his case because he has shown bias. What was the mental bias? He asked that I be served in court with a process. For goodness sake, how does that sound? But a lawyer, the civil counsel canvas that. Which is also why very few people who have practiced law in Nigeria before going to other jurisdictions succeed in those jurisdictions because they're already trained in certain behavior that cannot be taken wherever in any other place. Why should you know the position of the law? Several appellate court decisions for the time. And you come and say, I want to expand the law. I want to test the law. How do you use the defense? Your client's life. You might not pay you to come and test the law. He paid you to get solution to his problems. And then because you also want to see, you want to have appellate court judgments, you keep on appealing frivolous issues. These must not transact with other jurisdictions and sanctions. If we want our trials concluded in time, we also need to limit what is legally acceptable for a lawyer can pass within matters criminal civil. And talking of criminal matters, yes, we have rules dealing with the behavior of prosecutors. What of defense counsel? Must you see a case that is hopeless and still defendants bring in frivolous issues before the court? Other jurisdictions don't allow that. I remember a respected senior advocate here met one of the lady in the council, defended one of our politicians who was convicted in the land many years back. And the gentleman immediately tell him, so let this guy kills him. Then kills him, now you know they call them case. Why did you allow this man to be in court? His day in court. Why did you ask him to plead guilty? In this place, when the proof of evidence discloses what we have in that particular matter, it is my duty to advise my client to plead guilty. If he says no, I can advise right to him and let him leave from that. Over here, the client is rich, the case goes on endless. Everything comes back to what we allow, what we don't allow. Then we come to the totally unacceptable part. Counsel taking human briefs from themselves. Got to court and then they are different forces. The other person comes up and appearing for the same person, and both of them are displacing themselves. We are the noble profession. We are supposed to be exemplars in everything. I don't know how many people saw some of these social ranch, especially last Christmas when the gentleman standing on top of the stadium with some threatening notes that this man had to finish with you and all that. But he had to do that on the stadium because he can take the fact that has been caught by that tailor to another tailor to sew for him. No tailor will take over fabric that has been caught by another colleague. He will not tolerate it. You may find out. You give your job to a carpenter, and now people are rich, they can afford all the contractors. You give your job to a carpenter who feels, and you have to decide that that carpenter, if he comes down from that, you let that carpenter down. Unless and until it is allowed by the previous one. But what happens there? You find your colleague has not been properly taking care of the matter, take over the brief. Of course. What do they say in my language that the kid that used to spank the older wife is still waiting for the younger one. Yes, he's been studying after for the younger one. Why must we be the model? Look at it. When you take over these briefs, you look at what we disposed to in affidavit. Indicting your colleague, making disparaging statements about your colleague because of the clients that will come and go. You remain in the profession of your colleague. Why then do you call yourself an friend? Which is why I say we need independent enforcement of our rules. We need professional enforcement of our rules. We cannot afford to continue the way we are. Otherwise, the future of the profession will be in jeopardy. Those are my opening remarks. Thank you very much for your attention.
Well said. Going to hand over to Dr. Lincoln Usman, the representing advocate, for his remarks now.
Hello everyone. The chair SLP.
Okay.
Permit me to use this stand because I prepared a paper for one to a concept note to find the parameters of the theme of the seminar. I thought it was worthwhile to prepare a paper so that at the end of the day it can be shared to our colleagues. My learned brothers, distinguished learned friends, a very good morning to you all. I put up a paper that resonates with the theme of this seminar that I titled Ethics, Etiquette, and Navigating Ethical Precepts in Legal Practice in Nigeria. And in so doing, I dwell on the fact that ethical considerations are the foundation of practice of law, because it serves as guiding principle that shape the conduct of legal professionals and maintain the integrity of legal profession. You know, the main thing in our profession is that it is rooted in trust and confidence. And for you to maintain confidence and trust of not just clients that will brief lawyers, but even the society itself, you need to have ethics, etiquette, and ethical precepts. So, my intention in this talk is to highlight the fact that the legal profession plays a crucial role in upholding justice and promoting societal well-being, and adherence to ethical guidelines is essential for maintaining the integrity of the profession. Nigeria faces unique challenges in ensuring that legal practitioners uphold ethical standards given the diverse cultural, social, and political landscape of the country. So, in this presentation, we'll explore the complex intersection of ethics, etiquette, and navigating ethical precepts in legal practice, and delve into the intricate landscape of ethics, etiquette within the context of Nigeria, the ethical precepts as encapsulated in our rules of professional conduct, so that would ensure that at the end of the day, we create a legal system that fosters fairness, justice, and public trust. The roadmap to enforce ethical behavior in legal practice in Nigeria seems to me to be in three fundamental respects. One, promoting a culture of ethical conduct within the legal profession through education and training programs on ethical standards. Creating mechanisms for reporting on ethical behavior, establishing clear ethical guidelines and codes of conduct, and implementing mechanisms for monitoring and enforcing ethical standards, such as maybe we should have an ethics committee that will monitor and enforce ethical standards, aside from the disciplinary committee that we have, the legal practitioners committee. Maybe at the NBA level there should be an ethics committee that will do the monitoring and ensure that the enforcement of ethical standards are ensured. Finally, we have to create a supportive environment where lawyers feel comfortable and encouraged to make ethical decisions and report on ethical behavior. By the time we dwell into the details of that, we appreciate what that connotes. I did some definition of some terms around the theme, and then did a discussion of the roots of ethical behavior. You know, some of the behaviors are rooted in moral principles, in even sometimes culture and religion. But in examining the ethics and ethical legal practice in Nigeria, the main consideration should be on the ethical precepts that governs our conduct and we have a robust rules of professional conduct, which has been updated. The latest update is the RPC 2023. And in that rules, though this ones were a departure from the previous rules, because there's a second chapter that addresses the issue of money laundering, our responsibility in terms of money laundering. Rule 1 of the rules of professional conduct seems to me to be the cardinal principle of ethics, etiquette, and even ethical precedence, which, if properly appreciated, if properly communicated and imbibed by our lawyers, would help us to ensure that we have a profession that is maintain ethical standards to the admiration of the larger society and the development of the legal profession. And that rule says as follows: a lawyer shall uphold and observe the rule of law, promote and foster the cause of justice, maintain high standard of professional conduct, and shall not engage in any conduct which is unbecoming of a legal practitioner. By the time you dwell on the content of this very important rule, you'll see that all the core ethical obligations and responsibilities of lawyers are embedded therein. That is why it was crystallized by the Court of Appeal in the case of Gaby and Dahiru, where the rule was crystallized as follows: a lawyer as an officer in the chamber of justice owes a duty to uphold and observe rule of law, promote and foster the cause of justice, and maintain high standard of professional conduct and etiquette, and that he shall not by any means engage in conduct that is unbecoming of a legal practitioner. So we broke the rule into 4 fundamental parts. 1, uphold and observe the rule of law. And here we say lawyers must respect and uphold the Constitution and all the laws of the land, and ensure thorough understanding of the legal framework, so that actions of lawyers, their advice, and legal representation they give to their clients align with the principles and provisions that are encapsulated, provided, and enshrined in the Constitution and the laws of the land, other laws of the land. Lawyers as officers of court are expected to abide by the law themselves, while also advocating for their clients within the bounds of the law. On no account should a lawyer encourage a client to flout a court order or to disrespect a court ruling. If we observe this etiquette, sometimes you don't need to even enforce court judgments, because we will comply willy-nilly, having known that this thing has gone to court, has been ventilated, and a decision has been rendered. Lawyers are expected to comply with all the relevant laws, regulations, and professional rules governing their practice. This includes the adherence to the provisions of the Legal Practitioners Act, the rules of professional conduct for legal practitioners, following court procedures, and complying with ethical rules and regulations. Upholding the rule of law requires always maintaining professional integrity. This includes honesty, ethical conduct in dealings with clients, colleagues, and ensuring the preservation of the legal system. The second part of this rule, which we also discussed on, deals with promote and foster the cause of justice. We know that justice is the greatest man on earth. It is the ligament of the society, or civilized society. It is the cornerstone for human existence. It is very important that lawyers play a crucial role in promoting justice and ensuring that individuals have access to fair and impartial system of justice. And this including advocating rights of their client, working towards a just outcome in legal matters, and upholding principle of fairness and equality. Beyond that, lawyers have ethical obligation towards ensuring access to justice for all individuals regardless of their socio-economic status or background. Because where the situation demands, as lawyers, we should also, out of our rule to be the need to be socially responsible, also render legal services to those in need, including those who cannot afford legal representation. Lawyers have a sacred duty to observe the cap-rank rule by accepting cases in which they are duly instructed, which are within their area of proficiency in the profession. Lawyers are like taxi cab drivers queuing in a taxi rank. A taxi driver cannot refuse to take a passenger when it is strong, solely by way of discrimination on maybe his economic status or other factors. We know all the discriminatory factors. A lawyer should be socially responsible by accepting a brief pro bono, that is, not charging any professional fees when the need arises. And should also engage in mentoring other lawyers. That is why we commend the body of ventures in setting a good example by establishing a mentoring committee that started the act of mentoring, especially the new, and we should also engage in community service. The third arm or leg of this rule is maintain a high standard of professional conduct. Lawyers are expected to conduct themselves with integrity and professionalism. And we should know by virtue of our calling and the demands of the relationship between lawyer and client is a relationship of utmost good faith. And therefore it demands that we should demonstrate integrity, honesty in our dealings with our clients, and we should maintain the confidence of the client. These are all embedded in the rules of professional conduct, avoid conflict of interest, and treat all parties in a matter where they are with respect and dignity. Lawyers must maintain highest level of integrity and professional conduct. They should avoid any behavior that will bring the legal profession into disrepute, such as engaging in dishonesty, bribery, or other ethical conduct. Lawyers should strive to preserve, to be role models in their professional behavior and adhere to the highest ethical standards. And then the fourth aspect, component of it, there is more respect of the third one that by the time the paper is shared, you can go through. I'm trying to be conscious of time. Shall not engage in any conduct that is unbecoming of a legal practitioner is the fourth arm of the Rule 1. This part of the statement emphasizes that lawyers are held to the highest standard of ethical conduct and are expected to refrain from engaging in ethical behavior, any behavior, engaging in any behavior that will bring disrepute to the legal profession. Deceit, actions that will undermine trust and confidence of clients, colleagues, and even the public should be avoided. Lawyers have ethical duty to refrain from engaging in frivolous or malicious legal proceedings, just like my Lord has highlighted, giving us a practical example of what he has witnessed himself on the bench. Lawyers should not misuse the legal system to harass or oppress others. They should always try to resolve disputes efficiently and even peacefully whenever the need arises. Sometimes, like my Lord said, in criminal matters, when the proof evidence disclosed from a facie, you should follow the good example and do the needful. Then in civil matters, where you are served with a civil process and there is substance in it, rather than battling it all out, it is better to consider settlement out of court or resorting to some form of ADR so that the court will not be overburdened and the parties also will not be overburdened by the rigors of litigation. Lawyers should not allow their personal interest or outside influence to compromise their professional judgment. Lawyers should ensure that their advice and advocacy are objective, unbiased, and aim at achieving a fair and just outcome. Lawyers must avoid conflict of interest that will compromise their ability to represent their and undermine the rule of law. This includes disclosing potential conflicts and taking appropriate steps to address them. The ethical precepts that we talked about are encapsulated in our code of conduct. The code of conduct for lawyers, in which all our ethical, precepts are codified, is the RPC, which I have well highlighted, and I've just discussed the Rule 1. I've also gave example of the fact that it's a duty under the rules of professional conduct to report any act of misconduct to the appropriate body that is established for that purpose, that is the Legal Questions Committee. That's one way in which we can ensure compliance, enforcement of ethical behavior. We've defined what that means and what constitutes an infraction of acceptable standard of behavior, including infamous conduct and conduct incompatible with status of a legal practitioner. The courts have defined infamous conduct to be conduct in a professional respects. We have cited so many cases in which those decisions have been made. We give examples of misconduct, such as defrauding client, defaulting privilege communication, acting despite existence of conflict of interest, colluding with the client to commit illegality or fraud, or forgery, stealing another lawyer's client, like my lord has highlighted, which is sharp practice, and so many of them citing cases in which the LPDC have held that is a breach of the ethical code and have sanctioned lawyers appropriately. We should know also, because one of the ways in which we can enforce ethical behavior is through education. That's why we took the time to even show the standard when matters are taken to LPDC, and certain conduct that lawyers need to do, including you need to put your agreements with the client in writing, you need to give commensurate professional service, and you need to avoid the exercise of right of lying, and cited decisions of LPDC on that. And then we stated that in order to enforce ethical behavior, we must strengthen regulatory framework itself. Amendment has been done now, but there's one aspect that has been omitted in the current rules. In a lecture I delivered in 2020 here in Lagos during the annual general conference on the topic of incursion of multidisciplinary practice, I advocated for regulation of law firm. Currently, it is only the rules, the guidelines of the rank application for the rank of the rank of senior advocate that have a kind of regulation as to how a law firm should be set up. The rules of professional conduct has no such provision, and that's one of the reasons why we have incursions of multidisciplinary practice by the major accounting firms, which I mentioned in that paper is online. There is need to look at that aspect, because in senior clients, law firms are regulated, and that is also what is encouraging younger lawyers from avoiding pupillage and setting off what ordinarily would not be a standard practice, and starting practice when they are still being honed and need professional guidance. Then I also mentioned education and training, enhanced disciplinary process. I and Boma served in the LPDC 2 years ago, I think 2 years ago. My tenure ended last year, and we came up with the new rules of procedure in the LPDC. And we did something very good that I think my Lord will like, given his antecedent and where he did his contribution to the enthronement of the Lagos civil procedure rules, which later was adopted by Abuja and now is the norm across the country. We further reduced delay in the conduct of proceedings by crystallizing the witness deposition to an affidavit. Whereas a witness deposition has to be adopted in court by a witness, an affidavit is evidence in itself. So in the LPDC, what we do is you file statements and then have a verifying affidavit to verify all those statements and evidence, and attach all the documents that you need to use either to prosecute or to defend the cause before the disciplinary committee. And the moment the matter is called for hearing, whether counsels are there or not, once they file their papers, they will be adopted or deemed adopted. And then in one sitting, we adjourn for direction. So I think we need to amend our civil procedure rules to borrow from LPDC rules 2020 so as to reduce delay in proceedings. Then we need also peer review and mentoring. I've mentioned it before. We need whistleblower kind of policy so that we encourage a culture of reporting misconduct, not just by artists, by lawyers, but even by parties. The new rules of professional conduct will encourage, we have relaxed the manner in which proceedings are commenced before the LPDC. Now you can have a lay complaint. The person concerned himself can just go to LPDC and file a lay complaint, and proceedings will be started. And also, so many actors and stakeholders within the legal profession, course, the Chief Justice of Nigeria, the heads of all the courts, the President of the Nigerian Bar Association, Chairman of the Board of Editors are all given the latitude to report breach of ethical code, that's the rules of professional conduct. We also need to ensure more collaboration with professional associations to develop strategies for promoting ethical behavior among their members, and that is the work of this very important committee. Continuous professional development also to emphasize on ethics training in all our, and then monitoring, and we have to have a system of monitoring and auditing. Then I did an overview of the new Chapter 2 of Rules of Professional Conduct, which enjoin lawyers to do risk assessment, customer due diligence, record keeping, reporting of suspicious transactions, and having internal controls and training, and cooperating with regulatory authorities to ensure that we keep dry duty to the new RPC and align also with the recommendation of Part F. I conclude by saying that in conclusion, lawyers must uphold ethical standards and professional responsibilities required of them in their practice. A lawyer should not engage or allow his client to disobey court order. By adhering to these precepts and principles, lawyers can help to maintain integrity and credibility of the legal profession while promoting justice and upholding the rule of law. Understanding and adhering to ethics, etiquette, and ethical precepts are essential for lawyers to uphold integrity in the legal profession and ensure fair and just administration of law and justice dispensation. Nigeria should reinforce ethical behaviors in legal practice and maintain high standards of professionalism, integrity, and public confidence in the legal profession. I thank you for your attention.
Thank you so very much. And clearly we have a very in-depth paper here, which members of the section of legal practice of the Nigerian Bar Association will benefit from, because this will be uploaded to our members only section of the website and available to members of the NBA SLP for further use and research. So I thank you, Dr. Suleiman, Leonard Silk, and now over to Leonard Silk Chukwuka.
Thank you very much. My Lords, the chairperson of the section on legal practice, the chair of the litigation committee of SLB, learned senior advocates, distinguished colleagues. It's my pleasure to be here this morning, and I thank the leadership of the SLB for the opportunity to share my thoughts on this very important subject. Let me start by saying that the 2023 Rules of Professional Conduct, in my view, are to a large extent comprehensive. They make clear and concise prescriptions with regard to the standards of conduct legal practitioners in their dealings with the profession, in their dealings with their clients, in their dealings with fellow legal practitioners, and in their dealings with the court. So I subscribe to the view that the challenge we have with ethical behavior in Nigeria is not as a result of lack of legal prescription or of standards. I think it's largely a question of enforcement. And in my view, there are a number of factors that present challenges to enforcement of these rules. So I'm not going to waste our time to go through the I think they are written in very clear language. Anybody can pick up the rules of professional conduct, read them, and understand them. So the focus of my intervention will be the factors or issues that militate against full implementation and compliance of these standards. And the first that I would like to talk about is the procedure for discipline of legal practitioners. So we have a legal practitioners disciplinary committee which sits in Abuja and has responsibility to hear complaints against lawyers from 36 states of the Federation and Abuja, from the 128 branches of the Nigerian Bar Association. I think that does not work. That doesn't work at all. So if you look at the timeline for, disposing complaints that are presented against legal practitioners, you see that it takes an unduly long period of time. And even after the LPDC has issued a direction, there is a process of appeal to the Supreme Court. Now, and the law as I understand it is that once an appeal has been filed, whatever direction the LPDC has issued is stayed. Now, that appeal to the Supreme Court can take any time between 3 and 10 years. So the reality is that if a lawyer has misconducted himself or herself and a complaint has been issued, it may take between 10 and 15 years to have a final determination of that complaint. That does not in any way encourage good behavior, ethical behavior. So if we are having a conversation around how to improve ethical behavior and conduct within the profession, we need to take a look at the process of discipline of lawyers. Now, the second factor, in my view, is the process of dispensation of privileges within the profession. And I think that my Lord, Justice Yoyole, hinted at it. So today, if you want to become a senior advocate of Nigeria, the assessment is likely quantitative. It is not qualitative. So you're told that you need to submit a certain number of Supreme Court judgments, a certain number of Court of Appeal judgments, a certain number of High Court judgments. The question is whether we're doing a head count of these judgments, or someone is taking the pain to actually look at the quality of the judgments that are submitted. Now, because the assessment is likely quantitative, lawyers do all kinds of things to be able to meet, to get the number of cases that they need to apply to get this very coveted rank. So, a few years ago, I was at the Supreme Court on a Friday when the court was, giving judgments. And I think it was my Lord Justice Bieko, now retired. After delivering a judgment, he took about 5 minutes to criticize the counsel for the appellant. He said to the counsel, "You have in 2018 brought an appeal to the Supreme Court to ask us to decide whether it is the Federal High Court or the State High Court that has jurisdiction to try cases under the NDLEA Act. This was a matter we decided as far back as 2008. But you have brought this before us, you have wasted our time because you want to become a senior advocate." But that's not the story. The story is that after the court rules, the gentleman who had brought that appeal was elated and happily announcing that this was the 4th judgment of the Supreme Court he was looking for to be able to apply to become the senior advocate of Nigeria. In any other time, if a justice of the Supreme Court criticizes you in such a manner, you will never earn any privilege within the profession. So this, in my view, is the second factor that militates against compliance and enforcement of the standards that are prescribed under the rules of professional conduct.
The third is, I don't know how to describe it, but it's something that's related to our culture. And that culture is that if you're a big man, you are more likely than not to escape responsibility for your actions. So you ask yourself, since the inception of the Legal Practitioners Disciplinary Committee, how many senior lawyers have been held
accountable? How many of them have been debarred? How many of them have been made to face the consequences of their conduct? Now, related to that is also the culture of giving people a soft landing. And I was having a conversation with Attorney General Emeritus of Delta State.
We see it on a daily basis.
So you're driving a car, someone hits your car,
and the
person says sorry.
And if
you do not drive away with your damaged car, you see people around will come to you. He has said sorry to you now. What else do you want him to do?
Yes,
he has said sorry, but the question is, who bears responsibility for repairing the car? So this concept of giving people a soft landing, oh, he has suffered enough, oh, his rank has been withdrawn for 3 years, let us give it back. There must be consequences for bad behavior. If there are no consequences for bad behavior, we can, as much as we like, write all the rules in the rules of professional conduct, and that will not get us anywhere. Then the fourth point I would like to deal with before I yield the microphone is judges on their own path have a role to play in the enforcement of standards, ethical standards. Oftentimes,
so if you look at the rules of professional conduct that deal with the standards of behavior that are expected from counsel towards the court, they say that a counsel has to deal with, a lawyer has to deal with the court with, in good faith, utmost honesty, must not do anything that will impede the course of justice. And then someone brings a frivolous suit, or someone
responsible to bear those costs. So I think that our judges also need to understand the full extent of the powers that they have under the various rules of court and deploy them in maintaining and enforcing ethical standards. Before I finally yield the microphone, I started by saying that the rules of professional conduct make very comprehensive provisions. But there is one thing that I had hoped to see in the rules of professional conduct, which is not there. So recently, the Nigerian Bar Association, under the leadership of our president, came up with prescribed minimum payments. I don't want to call them minimum wages. Payments to be made to lawyers, depending on the geographical location where they are practicing. Now, I believe, my personal view, is that non-compliance with that prescription should be made a matter of professional misconduct. If the NBA has said that if you employ a lawyer in Lagos, that the wage you should pay to that lawyer to at least enable that lawyer to survive is 100,000. Any lawyer who employs another and does not pay, of course you can't take it to court to enforce because it's a matter of contract. But any lawyer who is an employer and who does not comply, it should be a matter of professional misconduct. By the way, one of the things that we have done in the new Rules of Professional Conduct 2023 is to make it an issue of professional misconduct when, as a lawyer, you do not charge the minimum fees that the MBA has recommended. So the question is, if failure to charge minimum fees can be a matter of professional misconduct, even though it's a matter of contract between the lawyer and his client, why should non-compliance with the prescribed minimum salaries or wages not be a matter of professional misconduct? I think it's something that we need to think seriously about. Thank you.
Thank you so very much. I have been totally enthralled, I have to say, by this presentation. It's working, you can hear me? Good. We have Joyce Otua, I believe, possibly on her. She's not with us. She'll be coming later on. So it's the floor is Thank you. Questions? Comments? I know we have quite a number of people online. The technical people are trying to get me connected so I can engage with our online participants. But I have a comment from the AG Emeritus of Delta State and chair of our ADR committee, Leonard Silk.
Thank you very much, Madam Section Chair. Thank you also to my Lord and my learned brothers for the very insightful interventions. I just wanted to make a comment in agreement with a lot of the points that have been made. The way I see it, I see, and I was speaking with my learned brother earlier, and I see a paradox between practice and policy. There is a huge misalignment. And I think in order to, we need to start having conversations as to how we're going to bridge it. And if I may, I'll just like to give 2 or 3 examples of how I see it. The first one, which I think is problematic, and I suspect this view will be very unpopular, but it needs to be said. As a body of lawyers, we like the idea of promoting the rule of law until it applies to us. I'll give a recent example. I won't mention specific names, but there was recent uproar regarding the requirement of lawyers to show evidence of payment of tax before filing court processes. And when I heard the backlash against this, the question that I thought to myself, are we saying that we as lawyers are exempt from paying tax? If we are not, then what is the problem? Well, the Legal Practitioners Act sets the minimum standards for practice or having a right of audience before the court. But the Legal Practitioners Act gave birth to the rules of professional conduct, which is now subsidiary legislation, and the immediate past Attorney General of Sokoto State read out Rule 1, which is that lawyers are to uphold the rule of law and not do anything that is unbecoming of the legal profession. So question, if we fail to pay tax the law, is that unbecoming of a legal practitioner? I think the answer is obvious. If it is, should we have a right of audience? So I think we need to be very careful in the way we're framing complaints. That is not to say there might not be legitimacy underlying the complaint, but we need to think of the consequence in the way we are presenting it. The second one I see is again tied to the duration of court proceedings, and I've seen in practice that again legal practitioners can be the problem. I agree entirely with Mr. Akwazo that punishment commensurate with the degree of infraction. And until we start seeing that, lawyers will keep doing it. Whether it's to get the number of cases you need for senior advocate or to please a client. I will borrow from Mr. Kukuboy in self-promotion. What we did in Delta State to try and tackle this, because we should now be focusing the conversation on solutions rather than reiterating we know what the problems are. So we enacted the Administration of Civil Justice Law, which seeks to do one of several things, and I'll give it the high level views. Firstly, it wants to stop the unnecessary filings of cases that should not be in the court. So what we did was we took an audit of the number of cases in the court, and we found that year on year, with the exception of or two gain of more cases are being filed than are being disposed of. So if you continue down that trajectory, you're going to have an upward curve of cases in the court pending, and therefore aggravating the length of time it takes to resolve them. So the first thing we tried to do was to say, is this case even necessary to be filed? Is it necessary for litigation? Is the question you should be asking. So the law forces the lawyer and the judge to start looking at what are the actual factors that are motivating the dispute. What are the factors that are motivating settlement or potential settlement? And the judge will then guide the parties in an initial meeting to say, I don't think this is suitable for litigation, explore mediation, at least in the first instance. Then if the case is necessary for litigation, then it wants to prevent a situation where, for instance, they will come and they will address your lordship to say, my lord, I haven't been served. It requires you now to state all the dates on which you will be unavailable as counsel and for witnesses. It requires you to state that all directives required of you have been complied with, including the service of processes. And to the extent that you are not prepared, you must tell the court beforehand so the court will not list your case for hearing. Because what happens, I was in the Federal High Court 2 weeks ago, with the exception of 3 cases, all were adjourned. And there were about 10, no fewer than 10 cases in the list. Now what does that do? It is eating up the court's time for unnecessary actions. If it's not listed, and you know that the ones that are listed, based on the procedures you have gone through, are ready for hearing, then the court can actually start scheduling you. Okay, how many witnesses do you have? 3? How long do you estimate? 5 minutes, 2 hours will be done. Okay, come at 12 o'clock. Come at 9:30. So I think we need to start shifting the conversations as to how we will start driving some of these solutions. I'm very, very grateful for the audience. Thank you.
Thank you so very much. You know, we don't have to reinvent the wheel. What we practice in this jurisdiction came from somewhere. There are 54 countries practicing the same law as we do, which is a common law. And what Silk has just said is simply what we do in England and Wales. All of these pre-action activities are dealt with at registry level. It doesn't come before the judge. You're not wasting the time of the court. By the time it eventually gets to the judge, it is for trial. And you have a trial window. You will tell the registry how much time you need, how many witnesses you need, and that window will be set for you. So if it's 2 days, it is 2 days. If it's 3 days, if it's half a day, if it's 4 hours, that's it. And there are consequences. If you waste that time, somebody will bear the cost. And it will not be the court. To be either party or the party's counsel if the lawyer has been unprofessional. So in England, when the court says to you, have you advised your client? You better go and think twice before you answer that question. Because you're bringing something that is clearly either incompetent or totally unjustifiable. And someone will bear that consequence. If you say you've advised your client, then the court will make your client pay. Or you will pay personally. Because there's a level of competence that's expected from us. Well, legal advisors. And as a matter of fact, if you've advised your client and you choose not to take your advice, should you continue to act? That's the question we need to ask ourselves. So, we have a company, we have hands up, please. State your name. Keep your comments brief. I'll come back to my note shortly. Let's give this an opportunity. Keep it brief. And your name. Thank you.
Good morning, my lords, and good morning, Chairperson. Good morning, Lenisilt, and my colleagues. My name is Patrick Osu. I just wanted to drive off from the comment that Emeritus HAG had made. He alluded to certain things that I consider very fundamental, and so has Madam Chairperson said the same thing. The problem with it is we do have in our rules, all right, Lagos State High Court rules, for example, we do have pre-action protocols. We do have attempts to start ADR before you even get into the courtroom. We have pre-trial conference. All of these things, when the rules came out, it was meant to make things easier, it was meant to make things faster. But I dare say, in my experience, it hasn't worked. Why hasn't it worked? Is it because the rules are not good? Surely not. Madam Chairperson just alluded to the fact that what we practice here and the body of rules that we have here are akin to what we have in 54 other countries of the world. And the question is, why does it work there and does not work here? So we need to drill down a little bit further. Do we have a personal problem? Do we have an orientation problem? Do we have a training problem? Because I suspect that's what it is. I had done a critique of the rules the moment it came out because I thought that, oh, they are nice and lofty, but I'm not sure it's going to work, and I'll tell you why. You file an action, you start with the action protocol. You file an action, it goes for registry assignment. The court will take it for an assignment and say go for ADR. Meanwhile, this is perhaps some litigation that requires some urgency. You file that, and it goes through that process. It doesn't even get assigned until 3 months after you have filed it, first of all. Then you're asked to go to ADR. You spend another 1 year in ADR doing really nothing, to be honest, because maybe the other lawyer has held on to his guns, he's not likely to settle, but unfortunately he has to go through the process, okay? So that's 1 more year lost for the clients, for the system, and for the parties that are involved. Then you get to courtroom. Then you start again. You get to one point where you have pre-trial conference. Supposedly, you should have identified the issues that you want to deal with in trial, matters that you want to discuss, or issues that are important for trial should have been sifted out and dealt with at that point. But you then come to that process where you say, we're now back to pre-trial. After pre-trial, because the judge who now sits in pre-trial is not likely to be a judge that's going to hear the matter. So when you finish that process of pre-trial, after a year and 3 months perhaps, you spend another 3 months or 4 months or 6 trying to do pre-trial. That file then goes back again to the administrative judges, who will now assign it to a trial judge. Now tell me, in all of these nice, rules that have been written, in all of these nice things that we see executed perfectly in other climes, why are we going through this? I cannot blame the rules, because in fact, after I'd written that thing and I'd experienced it in different matters that I've handled, I then said, why can't we go back to what we used to call Summons Federation Order 26, back in the older rules? It's just one shot. You come to court, Summons Federation, you're before the court, you've identified all the things on the form, the judge asks you when you're going to start trial. You say it, these are the number of people we have, and that's it. Same judge. So I am not sure whether the rule was intended to ameliorate the hardship. I'm not sure whether the exercise of it itself has been truly helpful. Now, these are the things I consider that we need to introspect, because more and more it becomes tiring for people who have been involved in litigation and enjoy doing what it is that they know how to do. It becomes extremely tiring. I was before your Lordship sitting here today in Abuja. I don't understand the reason why, if I needed to withdraw a defective appeal, for example, I needed to wait for a date. This is a matter that a colleague had filed. I had insisted that you required leave to file an appeal. Unfortunately, he said his own reading of the judgment meant that he did not need leave. When I got the judgment, I reviewed it again and I said, we actually do need leave, and therefore this appeal is incompetent. But at the time I determined it was incompetent, I should have been able to do an administrative process to end it, okay? But I couldn't. I had to wait for 1.5 years, almost 2, to come before His Lordship and his panel to then withdraw that appeal. Orders of the Court of Appeal rules for it to be struck out. I'm not sure that we should continue to engage in these sorts of perfunctory things and disturbing your lordships that have very important matters to deal with. So I think that we need to take a step back. Learned friends have said it. We need to look into these rules that we have again and see whether it's an implementation problem that we have, and therefore drill further down, training and all the rest of it. Thank you.
Thank you, Madam Chair. I thank you very much for your excellent presentation. I just would like to make this simple observation before I put my question to the Lord. I am not sure if the SLP thought over this topic very deeply before they featured it. To me, this should come up at a much bigger and larger forum of lawyers like the Annual General Conference, because this topic strikes at the very heart of legal practice in Nigeria. You know, when I saw it, I ran some issues through my mind. What could constitute unethical practice in Nigeria? The list is so large, so inexhaustible. I will face this every day. Sometimes we are helpless. You know, we all know that it is unethical for lawyers to come out of court while they still have their appeal. If just short of leaving their wig on, come out to face the media, comment, you see what the judge has just said and all that. And 90% of what they are going to feed to the public is misrepresentation, not true. They will read outside of what the judge has ruled. When this thing started, it was just like a joke, and I used to joke about it with senior lawyers. So how do you say, don't mind all the junior lawyers, they know it's unethical, they know that. But these very senior advocates are not doing it, especially in political cases. On a high level or in high level cases, they just rush out of court and say, well, what has just happened, I know that they are addressing a team of media houses of about 10. They are addressing TV and all that. There's nothing that can be so unethical as things like this. So the list is so one of such things that really bothers me is the issue of lawyers filing frivolous petitions against judges before the NJC. And judges, a lot of judges are not afraid. So a lot of people now see the NJC as an appellate court. Most judges, when they say, they have said, I've heard that they want to go to NJC. They want to protect their jobs. They want to retire peacefully without scandal and have their full benefit, but they are not afraid. So if we don't address these things, they will continue to wonder. And the juniors that are coming up will continue to imbibe all those things, thinking, this is the norm. So like I said, the list is inexhaustible. Let's escalate this to Annual General Conference. If we can replicate this same faculty, this same panel, I very much appreciate, like Leonard Emeritus. He brought us some very crucial issues. But because of time, you know what? I really appreciate what you said. But may I ask? This question is between His Lordship and let us say, Madam Chair. are we suggesting, except I did not understand the laws very clearly, are we suggesting that we create and set up a different body to discipline lawyers outside of what we presently have? Because I understand many people are complaining that the legal profession in Nigeria is over-regulated as it is right now. You have the LPDC, you have Body of Benchers, General Counsel of the Bar, Body of Senior Advocates. They all exercise some measure for discipline over lawyers. Are we supposed to create another body to discipline lawyers or strengthen those existing ones? I just want to understand what His Lordship meant to say a professional body to regulate this. It's already over-regulated in my narrow view. There are so many other bodies that are not mentioned, apart from the Professional Committee, Body of Benchers, General Counsel of the Bar, Body of Senior Advocates. They all exercise some form of regulation or the other. Thank you very much.
Thank you very much. At this point, I will cede the microphone to my Lord.
Well, thank you, Jude, for your observation and question. And in answering it, I will want to take the liberty to also speak on one or two issues that came up in earlier interventions. Straight to your question. If what we have in place is working, we wouldn't be where we are today. And again, I want to go to an example we can all relate with. Football match. A football match is played between two opposing teams. They don't donate members of the opposing teams to referee the game. Referees don't also bring rules outside the rules known to the players, but they are professional enforcers. What I am suggesting is that we take away enforcement of rules of professional conduct from bodies comprising practitioners, whether judges, whether legal practitioners. Let us have independent, professional enforcers of the rules. Then you will not be having the country club arrangement that we are having. Is my friend, is the son of this, is the father, is this? Oh no, I can't sit down here and allow my friend's son be the bad. I can't allow this one be this bad. Oh no, how do I explain to this? Unspoken, but practiced. What we call pedigree in the profession is just a whole line of favors and this and that that will end up ensuring rules are sidetracked. Whether, again, partnership matches, you've seen what happens even in a game where questionable decisions are made, everybody will protest, but you dare not touch the referee. You as much as having any slightest physical contact with the referee, that player is gone. But when we don't even respect each other in the profession, how do you even talk of judges who sit adjudicating? So what I'm suggesting is not just a question of new rules. No. The rules are there, but we need to look at our enforcement mechanism. If people know that there will be sanctions and the sanctions don't discriminate, they will sit up. When they know that whether you are a third generation senior advocate or just 2 years post-court, sanction once you cross the line, the difference will be there. But like I gave the example when I was making my earlier presentation, you cannot be given a cane and be told to spank yourself. You can't do it. We need to take enforcement of the rules of the profession away from the mechanism that we have now if we are to expect any reasonable change. Now, Lana Silk made mention of issue of cost. I personally believe that cost is one of the areas we can bring sanity into so many areas of our legal practice. But again, if you are talking about you bringing full indemnity, you must put materials before the court. If in filing your pleadings right from day one, you pleaded certain things which show, oh yes, the rules of professional conduct say I must not charge below this for this matter. This is what my client is paying for this. We have had pre-action protocols, whatever, and this matter was advised for settlement. The other party refused to settle. But because of the refusal to settle, we are incurring so much in filing, we are incurring so much in cancel fees, we are incurring, plead it. When you are victorious, you have the right to demand it. Because he had a chance to settle, he did not. He brought this on you. If the court does not rule on it, you have the materials upon which you will find your appeal. Now, the court cannot just assume that, oh, you must have spent 5 million in the lower court. You must have spent 10 million on appeal. We can't do that if materials are not placed before the court. But I also believe strongly that cost will help instill ethical behavior. When I was in Lagos, I remember when I was in the fast track court, I will schedule my matters. I will look at you, look at it, how many witnesses, 5 witnesses, don't worry. We take, it may be 2 months, maybe 3 months, but we'll clear 3 days for you. You will do yours, you will do his, you will address me on this day, and this is that. We all agree. Typical of counsel on the first day, after you've taken the witness and examined, my Lord, I want to apply that we vacate the second day. Because just kindly, I will look at you, no problem. But if whatever you want to do will be worth 500,000 naira, you will go ahead. I'm talking of about 15 years ago. So when you say that, okay. And I just remember I can send my junior. I think I will come. Because they know I will put the 500,000 naira there. And you don't come before my court and say, my senior is coming to take the matter. When you call to the bar, that's why you are addressing me. Sit down and study your file. I will give you 30 minutes, 1 hour. I will take other matters. By the time I come back, you better be ready. And we achieve results. Now, once, it's like when you are bringing up, everything is all about testing of will. They test your will and they know that this one is not yielding. It's a simple thing. When we came into the profession, the patrons, the patriarchs rather of the profession back then, and up to when I even became a judge. I give an example to the moderator earlier on. Chief FRA Williams did matters before me when I was in Lagos. FRA never came late to court. He never came. He will be there. 30 minutes, 15 minutes before the court starts, he will be there. Because leadership is by example. With his height, with everything, by the time you knock that door and you come up as a judge, you see him there, standing. And of course, thereafter, you allow him to address you sitting down because of his health. But he will not saunter in or tell a junior, tell the court I'm coming in at 11, they should stand the matter down. It is totally unethical. Because sit at 9, you should be there at 9. The matter at 11, you inform the court earlier, and your matter will have been fixed for 11. I said, things we do, things of cancellation, you have no business sinning. And if your client, I say, and I've said it to one or two judgments, that look, when you say, when the client picks a client that will sin, then you must pay the consequences. Let him look for one that will not sin. You don't tell me, and it is not, why should you come late to court and allow your client's case to be struck out? And you are now saying you are the one that got stuck in traffic. It wasn't that traffic came overnight. If you live in Lagos, traffic had always been part of us. So you make provision for it. So we've been excusing too many things. And I also think, yes, sanctions will help us decongest the court. We must be ready to impose. We just need that willpower. But I'll keep on advocating it until one day it happens. We need to take enforcement away from our own internal. We can't be doing self-regulation and expect progress. We need to move it away to professional, independent regulation. Thank you.
I thank you. And I have to say that what my Lord is advocating is precisely what has happened in England and Wales. I keep referring back to that because this is where this law came from. What we're doing today is what they were doing 150 years ago. And we can fast forward it to be where they are now, working far more efficient. So there is this SRA, and the SRA is not manned by lawyers, professionals in different capacities. That's a solicitor's regulatory authority. And then there's the Law Society, which looks after the lawyer's interests. So that would be the embassy. And that division of responsibilities came as a result of recognizing the conflict in representing profession and disciplining profession. So, my Lord, you are preaching to the converted. We have online a question that's addressed to Kwazun SAN, and it says here, Mr. Chukwuka Kwazun SAN struck a point in his submission about lawyers who file frivolous cases in court to make up their cases for qualification to take silk. What measures can we put in place to ensure that these privileges are not extended to unscrupulous lawyers or those who are desperate to be elevated at all costs? How do we move from quantitative to qualitative standards in admitting senior lawyers to the inner bar? It would appear that there are sacred cows in the legal profession. How do we deal with this to correct the impression that some lawyers are untouchable or are so connected to be punished for unethical behavior? Question is from not so as Esquire.
Well, I think that question is fully loaded. And I'll attempt to unpack the question and answer it. But I guess the starting point is to say that even the rank of Senior Advocate of Nigeria, we borrowed from somewhere. You know, all through this session, the chair of SLP has been talking about, you know, these things that we're doing. We don't really have to reinvent the wheel because they've been done elsewhere. Know that in England, if you're applying to become a King's Counsel, you're required to present, I think, 7 cases, your best cases. So it's perfectly possible for you to become a King's Counsel without having appeared at the Supreme Court or even the Court of Appeal. So rather than, you know, ask applicants to present 20 cases from the High Court, 5 from the Court of Appeal, 4 from the Supreme Court, you can ask them to present their best cases, the best cases
ever did, that dealt with novel issues of law. And then I think that the LPPC, the Legal Practitioners Privilege Committee, has taken a step in the right direction by now insisting that applications are made electronically. Because what used to happen in the past is every applicant will, get loads of documents, take them to Abuja, dump them at the Supreme Court. And then during the filtration stage, a few members of the committee will come over a period of a day or two, and then they don't really have the time to start to go through the paper applications to look at all the cases. Now applications are submitted electronically, and I understand that members of the committee have access to these applications, so they're able to have time to look at those applications. So I think that that's a step in the right direction. It shouldn't stop there. They must create a process that ensures that every single judgment that is submitted in support of an application, there's ample time to go through it, to look at what the issues were, what if the judges that heard those cases have made any adverse comments on the reputation integrity of the lawyers who did those cases. I think that those things should count. And then the process of getting recommendations from judges is also an important process, and I think that that should be taken a lot more seriously. Judges should be informed that they need to actually drill down, in their recommendations to commenting on the suitability of the candidates that they are recommending, and all these things should be taken into account. If we do all these things, I believe that will significantly improve the process. Thank you.
Thank you very much. I'm very conscious of the time, and so I'm going to give each of our distinguished panelists an opportunity to say a few last words before we round up this session. Starting with Dr. Suleiman Silk. 1 minute, then Milord, and thank you.
1 minute sufficient. I think what my Lord has advocated is good, if we can consider it. But before we get there, we still have examples we can leverage on. Examples from election petitions, how they are conducted and concluded, timelines that are hardly altered, even if applications are made by lawyers. If we leverage on that, I think we can do a lot in eliminating. The most important issue, apart from the fact that we have robust rules, comprehensive rules, we have to look at the persona. The chair will agree with me, when LPDC was chaired by ECO, SA, nobody goes to LPDC and try to waste time. He strictly imposed the rules, and within matters of days, he cleared so many cases that created a large chunk of the backlog that had been handled. So look at the person. We still have those that have the will to be able to enforce the law, like my Lord. It's a good example. So maybe we have to also look at the process of putting people into those bodies that regulate the profession. By the time we come up with people that have the necessary credentials to implement and enforce these rules, I think a lot can be achieved, and most of these issues can be reduced to literacy. So that is also part of the work of the SLP, to continue to advocate for that, and to also come up with proposals like done by the current leadership of the MBA. I commend them, because in one fell swoop they brought up the issue of amendment of the rules of professional conduct, the Legal Practitioners Remuneration Order 2023, they ensure also the General Council of the Bar that was not in place was properly elaborated. And even the Chapter 2, for the first time in the history of our profession, has seen the light of it. So with that kind of mindset, that kind of output, we'll do a lot in ensuring ethical standards and also maintaining the integrity of our profession.
Thank you. Let me just, in rounding up, refer to the issue earlier mentioned about payment of good remuneration to juniors in law firms. I think even if it is unofficial, we can insist that the same way applicants for the rank of sale file their tax returns, they should also include the tax returns indicating how much tax is paid by their juniors, which will show how much has been paid to each one of them as monthly salaries. So that whoever is undeserving will be eliminated even at that level. And that this should be made for everybody who is highly sale. You should make it an annual thing, because getting there is not, for many of them, they want to get that rank and thereafter they relax. Maintain yourself at that level so that it is a yearly affair. You must submit to the bar or to the committee of the body of bankers on a regular basis what you pay as staff, pay as you earn or whatever, or juniors working in your law firm. That, I believe, may help. But what I believe will still help even now before we put certain things in place is the issue of sanctions. We should encourage judges, we should encourage even ourselves to demand sanctions when we see people going astray or bending the rules. And I believe with time, when people know that when the judge pronounces your matter frivolous, it must be sanctions. You don't leave that place and expect not to get summons from the disciplinary committee of the bar. So, I believe this is the best profession in the world, but making it so depends on all of us. Thank you.
So in closing, I'll say that we really need to decide the kind of profession that we want. One thing that is clear to me is that this trajectory that we are on, we cannot afford to continue on it. If we do not do something, and urgently too, in the next 10 to 15 years, we may not have a profession to call our own. So we must all drive the change that we want to see. I agree with my Lord that we need to seriously consider, because self-regulation is a privilege. The problem we have in Nigeria is that we have enjoyed that privilege without accepting the responsibilities that come with it. So as long as we're not willing to accept the responsibilities that come with it, we must dispense with it. I think that in the meantime, we need to decentralize the LPDC. Like I said, it does not make much sense to me that one body that sits on an ad hoc basis will be hearing complaints against all lawyers in Nigeria. We need to do something. If a lawyer misconducts himself, it sends the right signal. If within a matter of months, that lawyer can be disciplined, it sends a very strong message that the legal profession is not willing to tolerate misconduct. And finally, on the point that I made, which my Lord commented on, today,
in Nigeria to hear that there are lawyers who employ our younger colleagues. They don't give them letters of employment. They don't have any fixed salaries that they earn. Some of them, only when they go to court, they give them what they call appearance fee. So during COVID, when the courts were shut, or if anything happens and the courts are not open, they don't get to earn a salary. If we're talking about conduct that brings the reputation of the profession down, this is one example of such conduct. So we need to do something about it. Thank you.
Distinguished brothers, I think this panel deserves a bigger round of applause. Hello, all the way from out of and back into Lagos, fellow. And I will say thank you for your time. My brother still, hello, University of Liverpool alumni, all the way from Sokoto. I'm the candidate. Thank you very much. My friend, my partner, my brother Silk, thank you so very much for your time. Today is simply this. It is not the severity or the penal provisions of any of our rules or even our statutes that matters. It is the certainty that they will be implemented when there's any infraction that is important. I suspect, borrowing from the comments and questions made by Jude and Patrick, we will, as a committee, drill down on this issue. And I have the backing and support of my chair of section that will definitely see something done for coming at our conference of Nigerian Association. Thank you very much, distinguished colleagues. As we round up and move quickly to session 2, we have two things. We'll have a quick photo shoot with the members of the panel, and then we have, you don't come to SLP and go away with anything, with nothing. If young lawyers can get journals, you can imagine the little thank you we would have for our esteemed panel. So we have some, can we have our chair session make comments about our presentation? Well, to the chair of session first, you are the moderator. A little token of appreciation from your committee to you.
Yes. Thank you.
Although I last appeared before my Lord in Calabar many years ago. My brother still, Ismail Suleiman, the Emeritus, Sokoto State, and the esteemed member of the section. And finally, Shuku Kaikwazom, Senior Advocate of Nigeria. Thank you so much, sir. We just have one final photograph with members of the panel, and then we're done for this session. The barcode, this session is ICLE, it's accredited. So,